about landowner liability, and then later on I'm going to talk a little bit about business organizations and transferring property. But this is sort of an outline of what we're going to talk about today. We're going to cover concepts of negligence and premises liability. We're going to go into a little bit more depth, a little bit more detail than Tom did during his presentation. We're going to talk about limiting liability through the use of business organizations. And finally, we're going to talk about transferring property to the next generation. So succession planning, estate planning, just touch on that a little bit. The worst thing about lawyers, well, one of the worst things I can say, is exactly what Becky said this morning. A lot of answers are it depends. It's the worst thing in the world to have to say, but it's very, very true. Everything that we have to say and everything that we talk about, it's very fact specific. So what happens in one case might change completely to what happens in a different case, depending on just one tiny little fact. And courts make determinations of fact before they even get to the law, which is why these cases can turn out so differently from one place to the other. So unfortunately, a lot of the answers are, it depends. And that's just, depending on the facts, it can go one way or it can go something very, very different. So premises liability is based on a legal concept called negligence. And negligence is the failure to exercise reasonable care that a reasonably prudent person would exercise in the same circumstances. Clear as day, right? Let's break it down a little bit. There's actually 4 parts to any negligence action. There's 4 elements that have to be met, which means if you can only meet 3 of them, if you're the one that's bringing the lawsuit and you can only meet 3 of the elements, you're not going to win. You have to meet all 4 of them. On the flip side, if you're the one defending against the lawsuit, if you can prove that one of them is not taking place, then the person who's suing you is not going to win either. So these 4 elements are first, a duty of care. You have to have a responsibility either to do something or a responsibility not to do something. It's your responsibilities as a landowner, because right now we're talking about landowner negligence, landowner liability. And this is typically what is called a reasonable person standard. And again, a reasonable person is, it depends. It's one of those things that varies from place to place, from person to person. But generally speaking, it's the judge has to think about what a reasonable person in that situation would do. That reasonable person can become very different depending on the situation. So a reasonable forester might have to behave differently. A reasonable person who has training in forestry might have to behave very differently than a reasonable landowner who has no training at all. A reasonable lawyer would have to behave very differently from a reasonable doctor, depending on the situation. A reasonable person in the same or similar circumstances. So this is age, it's training, it's a lot of different things that a reasonable person is determined by. But that's what governs the duty of care. The second element, the second thing that has to be shown, is that there's a breach of duty, that there is a problem, that you didn't meet your duty. It was a failure on your part regarding your responsibilities. After you have the duty and you've established the breach, you have to determine causation. So your breach of duty, so something you did that you shouldn't have done, or something you didn't do that you should have done, so caused the damage. So to break it down a little bit further, something you did that you shouldn't have done. Tom talked about it this morning, putting up barbed wire to stop people from driving ATVs through. That's an action that you affirmatively did, that you went out there and you strung the barbed wire. What's something on the flip side that you didn't do but you should have? If you have a dead tree in your property and you have an agritourism operation or some sort of operation where you have people there, you might have a responsibility to remove that dead tree. So that's something you should have done, but you didn't. So that just shows you the 2 ways that you can have liability attached. So that thing that you did, or the thing that you didn't do, they have to cause the injury. So if you have a tree there and it falls over and it doesn't hurt anybody, then there's no injury. There's nothing that caused it. So there would be no liability, no negligence would attach. And the final is actual harm. So if that tree did fall and didn't hurt anybody, then there's no damages and there's no negligence. So these are just things you have to have, all four of them, before a negligence claim can succeed. So let's assume that you've gone ahead and you've invited people out to see the lightning bugs, or you've invited them out to see the butterflies or the hummingbirds or whatever else it is that you have and you invite people on the land. The first thing you need to ask yourself is, how do they get there? Because your responsibility, your duty to them, can change a lot depending on how those people got on the land. Do you know that they're on the land? That's the first question. Are they trespassers? Are they just coming on without your knowledge? Or did you invite them to come on the land? Did you go even farther and charge them to come on the land to see the birds or to see whatever it is that you are going forward in your operation with? Another question to ask yourself is, did they ask your permission? Obviously, if you're charging them, they asked your permission to come on the land. But even if you're not charging them, did they ask, can I come on the land, and where on the land can I come? So there are three, once you ask yourself those questions, there are three different categories, and Tom talked about it a little bit this morning, three different categories that these people fit in. There's the trespasser, there's the invitee, and the licensee. For the trespasser, there's actually two types of trespassers. We'll get into them more on the next slide. But you owe the trespasser the lowest duty of care. So imagine it's a spectrum, and you owe the trespassers on one side with the lowest amount of responsibility to them. Because you don't know they're there, you didn't invite them there, and they're certainly not paying you to be there. The next step up is what's called a licensee. And that's in the middle of the spectrum. And you owe a higher duty of care to the licensee than the trespasser, but not as high as the one on the far end of the spectrum. And that's called an invitee, and you owe them the highest duty of care. These are all legal words. They have very weird definitions. We're going to go through them step by step later on. Just the concept to keep in mind from this slide is different duties of care depending on the person and depending on what their role is on your land. So with trespassers, it's somebody who entered on the land without your permission, somebody that or your invitation. And you have really two different standards depending on whether or not you know trespassers are there. If you have no knowledge that there are trespassers there, you have no duty, you have no responsibility to that person, which means that they can't meet that first element, the duty element, because you do not have a duty to them. However, if you know that the trespassers are there, and you can know in many different ways. You might see them there, or you might have a pond out on your property and go out and find tire tracks and cigarette butts. In that case, you don't know the people that were there. You don't specifically see them there, but you have some idea that people are trespassing on your land. Or if you go out and there's ATV tracks in places that you weren't driving. Those are different ways that you have knowledge that the trespassers are coming onto your land. You're not inviting them, you don't know who they are, but in this case, because you have a known trespasser, you have an obligation not to do anything that will harm them. So you can't go out and set booby traps. As Tom was saying this morning, you can't go and put a strand of barbed wire across the trail, because you cannot do something for the sole purpose of harming the people, harming trespassers. Even though you didn't invite them on your land. That's just the way it is. You cannot do anything that will affirmatively harm these people. So, for an example, if you have teenagers that are going out to your pond and fishing without permission, you can't go out there and put alligators in the pond, something that will harm them for the sole purpose of getting them to go off your land, to leave your land. So here's a good example. This was actually on the Craigslist, which is an online sort of garage sale thing in Fayetteville, Arkansas. This was just up just recently. And it says, I'm hoping to find an aggressive bull that is protective of his field. I'm wanting a very aggressive one that will chase people off. Is that something you can do? No. Obviously, this gentleman has trespassers. Obviously, he knows about the trespassers because he wants this bull for the sole purpose of chasing these people off. This would be the setting a trap. This is not something that you can do, and especially not something you should advertise, even though you do want a mean bull. So this is just an example of something not to do going forward. Trespasser, invitee, or licensee, do not do something like this. So we've talked about trespasser, which is on the lowest end of the spectrum. Yes, ma'am.
So you have a place that you know you've seen evidence that people have been there. You don't set a trap, but are you responsible then if they go there because you know they're there? And you put up signs that say no trespassing, and then will that protect you from if they go in and get hurt?
You can put up signs that say no trespassing. You can fence it off. You can do things that aren't setting a trap for them. And once you do that, they're still going to have to make those 4 elements. They're going to have to prove that you had a duty and that you violated that duty and that they were hurt as a result. Nothing is going to protect you 100% from a lawsuit. Nothing we tell you today, nothing you learn anywhere is going to protect you. What you're trying to do is just provide layers to make it harder to be held responsible. So one thing, that what I was just saying is you don't set a trap because it's going to make it a lot easier to be held responsible. But you can do different things as long as it's not setting a trap to harm these people. But I know this happens all over the place, especially with people who own forestland, because it's not necessarily something you go out and check every day. You know, it's a lot of absentee landowners and a lot of different issues. But these are different things you can do, hopefully to provide a couple layers of protection to put between you and the court system. Did you have a question? Nope? Okay. So a licensee is a little bit higher up on the duty, on the responsibility that you owe to them. So we have trespassers down at the end, and licensees are in the middle. And a licensee is somebody who comes onto your property just because you let them, but not because you're charging them. So it would be a guest in your home, or somebody who just comes out to your property to walk around, but you don't charge them a fee, don't charge them any entrance fee. For a licensee, your responsibility is you can't harm them from willful or wanton conduct. You can't go out and set booby traps for these people, which is what you owe trespassers, right? But there's one more step for licensees, because you owe them a little bit more. You also have to warn of hidden dangers that the person wouldn't see and is unlikely to know of. So if you have a sinkhole that's sort of hidden by the brush, hidden by the trees, and this person's out walking in the pasture where the sinkhole is, you should say, hey, you don't want to go in that corner of the pasture, there's a sinkhole. Or if you have a nest of rattlesnakes that this person wouldn't know about, you have to tell them. Just say, hey, you might not want to go there, there's rattlesnakes. Just different dangers that aren't obvious to everybody, aren't obvious to this person because they're not as familiar with the land as you are. And you just have to say, hey, you don't want to go over there, or hey, watch out, there's something in this area that might hurt you. So if somebody comes to you and says, do you mind if I go hunting on your land? They don't pay you anything, which makes them a licensee. You need to warn, for example, as we just talked about, of the bull that's not fenced in, or the nest of rattlesnakes that they wouldn't know about. What about if you had a pond back in that pasture? A pond is not necessarily a hidden danger because it's something that they can see. So you wouldn't have to say, hey, there's a pond, be careful, you might drown. Because they can see the pond that's there, and they can comprehend the possible injuries of going near into that pond. On the far end of the spectrum, the most responsibility that you owe to somebody is people that fall in this category of invitee. And people who are invitees are people that pay you to be on your land. So if you charge money to have people come and look at the birds, or to come and look at the butterflies, or anything else that you have that they would like to come and see, that would be considered an invitee. If you own a store, your customers are considered to be invitees, and so are any employees that you have working for you. And you owe these invitees the highest duty of care. You have the most responsibility to them of any group of people. And you have the responsibility to use what's called ordinary care to keep these people safe. So typically these are the people that you show the most concern to anyway. Those are the people, if they're paying you to go birding, you want them to come back. So you want them to have a safe and fun and pleasant experience. And again, employees are also under the duty of care of invitees. So if by chance you hire somebody to work with you, you'd also have to show this ordinary care to them. So the status of somebody on your land can change very quickly. If I come on the land as a trespasser, I'm not necessarily going to be in the same status everywhere I go and at every point in time. And here's an example of that. If you allow somebody on your land to fish in your pond, they're fishing for free. They are a licensee. But if they say, well, I'm sick of fishing, I want to go exploring a little bit, and they go in parts of the land that they weren't given permission for, they've now changed to be a trespasser. So you owe them a different duty of care in the parts of the land that they weren't given permission. But you're out there and you say, hey, you're not supposed to be in this pasture, I didn't give you permission. And this person says, okay, well, let me give you $40 and that way I can explore all I want to without a problem. At that point in time, that person's status changed yet again. And now they're an invitee. And you owe them a different duty of care at each point in this trip. So it's not, just like everything with the law, it's not cut and dry. But it's just important to realize that the status can change and your duty can change depending on where that person is and what they're doing. As a result, it's important to define the areas where people have permission to go. So if you have a facility where they're going birding, if you only want them to stay on a certain part of the land, you have to let them know that. You have to mark it off and give them maps and do everything that you can to make sure that they know this is the part of the land that you're allowed to use. If they go beyond that, then your duty of care can shift, as long as they know this is where I can go. So that's everything I have on landowner liability.